loans. Well, for decades, NCAA athletes playing in big-time games meant big-time paychecks for colleges and universities. But a new Supreme Court ruling tonight has the College Association on its heels, as student athletes have the all clear for a payday. Tonight, our Rebecca Fiedler is in College Station to find out how this new ruling will affect Texas's largest universities.
For years, student athletes have been barred by the NCAA for earning salaries for their work. While that restriction still stands, this landmark decision by the Supreme Court opens up more compensative opportunities for students. The Houston-based law firm of Charles Sanders and Erica Rose represents athletes in sports law. Sanders, an Aggie alumnus passionate about the subject of student-athlete rights, says that his firm has been approached by students in the past who wanted legal representation.
I was always waiting for this decision to come out because I didn't want to make any promises when they come in that I could do this, this, and that when I knew there wasn't nothing that I could do.
Sanders and his associate, 3L law clerk Jay Wright, discussed some of their interactions with athletes and the perceived plight of these young professionals who are not paid directly for their dedication and physical risk.
I really wish athletes had the opportunity to actually withhold their labor from the NCAA. You know, a lot of them are exploited. They come from communities that are not the greatest, financially lacking resources, and getting the opportunity to have a nice meal in your own bed, it sounds good in theory, but when you're giving so much talent and so much hard work and dedication to these topics and to these ideas, you deserve to be justly compensated.
Historically, athletes like former Aggie quarterback Johnny Manziel have spoken out against the NCAA's rules. The legal team expressed disgust with the NCAA's policy for not offering players salaries. The reason it took so long, even to make a stride like this one seen today, Sanders and Wright believe is due to industry greed.
If you put all the schools together, the SEC, especially the SEC schools, I mean, billions and billions of revenue is at stake. And you could say that they're almost exploiting athletes. These players work their butt off to get there. And the schools are taking advantage of the fact that they can make money off their players and the players can't do anything. And every time they take any type of compensation before this NCAA double violation.
As reported by the Associated Press, the NCAA's stance on the issue regards the perceived blurring of lines between college and professional sports and the diminishment of the amateur nature of college sports. The NCAA is working to change rules about students profiting from the use of their image and likeness for advertising revenue. Reporting in the Brazos Valley, Rebecca Fiedler, KRHD News.
And the Supreme Court dealt a significant blow to the NCAA today. The justices unanimously ruled in favor of a group of college athletes that sued the NCAA for violation of antitrust laws. As it stands now, the NCAA allows schools to pay for expenses related to education like tuition and books. However, student athletes don't receive any of the billions of dollars made from ticket sales, television contracts, and the merchandise featuring them. The NCAA argues that the spending caps at issue were necessary to preserve a distinction between amateur and pro sports. The White House says this is a big win for labor rights across the U.S.
And today's decision recognizes that, as with all Americans, their hard work should not be exploited. And the president believes that everyone who works should be compensated fairly for his or her labor.
And Justice Brett Kavanaugh wrote, "Nowhere else in America can businesses get away with such actions." He continued, "Under ordinary principles of antitrust law, it is not evident why college sports should be any different. The NCAA is not above the law."